dear students, I welcome you all to today's lecture on the constitutional validity of the restitution of conjugal rights under Hindu law. The objectives of today's lecture are: number 1, to study the object of marriage; number 2, to study the evolution of the concept of restitution of conjugal rights; number 3, to understand the meaning of restitution of conjugal rights; number 4, to understand the constitutional validity of the restitution of conjugal rights; and lastly, the ulterior motives in petitions for restitution of conjugal rights. First, let us have a look at the introduction. Marriage gives rise to a very tender but to complex interrelationship between the spouses, from which a plethora of rights and obligations arise. These rights and obligations cumulatively constitute conjugal rights and can be termed the essence of matrimonial union. According to Hindu philosophy, there are 3 objects of marriage: dharma, that is justice; praja, that is procreation; and rati, pleasure. For the success of married life, there are 2 prerequisites. They are virtue and love. Here, virtue means dharma or justice. It is general rule that each spouse is entitled to the society and the comfort of each other, and if any spouse without the reasonable cause leaves any spouse, the latter can move to the court for a decree of the restitution of conjugal rights. Restitution of conjugal rights is a remedy which basically means a restoration or reinstatement of one's marital rights or privileges, like comfort and consortium of one another, which the marriage or the marital bond entitles him to. There is a uniform provision regarding restitution of conjugal rights in all the personal laws. Now, let us have a look at the evolution of the restitution of conjugal rights. The remedy of restitution of conjugal rights was not recognized by Hindu law, that is, by the Dharma Shastras and the Vedas. The Vedas recognized the necessity for a son, for it relieved his father from hell called Put, resulted in the desire for a male offspring for the continuance of the family and for the performance of funeral rites and offerings. Consequently, the sacredness of marriage was recognized. The texts of Hindu law also recognized the principle, let mutual fidelity continue till death. Hindu law enjoined upon the spouses to have the society of each other, while the old Hindu law stressed on the wife's implicit obedience to her husband. It did not lay down any procedure for compelling her to return to her husband against her will. It became necessary to find some remedies and procedures so as to see that the marriage is intact and would not be disturbed by petty quarrels between the spouses. The Jewish law provided for the remedy of restitution of conjugal rights. From the Jewish law, the remedy was adopted in English common law, and from common law it was introduced in our country by the British rulers, at least from the time of the decision in Munisha Bazlur versus Shamsu Nissa Begum. This case clearly marks the advent of such relief and the current law in India. A decree of restitution of conjugal rights implies that the guilty party is ordered to live with the aggrieved party. The concept of restitution of conjugal rights owes its origin to the ancient days when the concept of marriage was based on the proprietary rights of the husband. The wife was considered as the property of the husband and was therefore required at all times in the home provided by her husband, and if she refused to do so or ran away, she could be compelled to live with him. Originally, the decree for restitution of conjugal rights could be enforced by the arrest of the respondent and the delivery of her person to the husband. Later, the remedy was made available to the wife also, and the enforcement of decree by arrest was done away with. This remedy was subsequently done away with in England, but such remedies did not bind the Indian courts, wherein the procedure had become statutorily recognized. After independence, this remedy found place in the Hindu Marriage Act 1955. When the provision in the Special Marriage Bill and the Hindu Marriage and Divorce Bill was being debated in Parliament, many members voiced their opinion against it. J.B. Kripalani said, I quote, "This provision is physically undesirable, morally unwanted and aesthetically disgusting," unquote. Mr. Khardekar had opposed the remedy, saying, I quote, "To say the least, this particular cause is uncouth, barbarous and vulgar. That the garment should be abettors in a form of a legalized rape is something very shocking," unquote. Sir J. Hannan in Russell versus Russell also vehemently opposed the remedy, saying, I quote, "I have not once known a restitution petition to be genuine, that these were merely a convenient device either to enforce a money demand or to obtain divorce," unquote. Some scholars have even expressed the view that the remedy should be abolished. The viability of such opinions would be further examined. Like any other anachronistic remedy, the restitution of conjugal rights dates back to feudal England, where marriage was primarily a property deal and the wife and the children were part of man's possessions as other chattel. The remedy finds its origin in the ecclesiastical codes of England. Before 1813, the sanction of such a decree was excommunication. Later on, 6 years' imprisonment was substituted by the English Parliament. Hence, a decree could be executed by arresting the wife. It is remarkable that many other anachronistic common law actions were gradually abolished, but they survived in English matrimonial law. This remedy was retained in capitalist England, though some of its stings, contrary to the concept of equality of sexes, were picked out. The decree could no longer be executed by the arrest of the respondent, but it could be by the attachment of the property. Later on, this mode of execution of decree was also abolished. The non-compliance of the decree amounted to constructive desertion, thus becoming a ground for divorce. The modern English law has fortified the wife's position by making adequate financial provisions for her. The British Law Commission, presided by Mr. Justice Scarman, in its report dated 9 July 1969, recommended the abolition of this remedy. In English law, which leads to Section 20 of the Matrimonial Proceedings and Property Act 1970. This act abolished the right to claim restitution of conjugal rights in English courts. Now, we shall discuss the remedy for restitution of conjugal rights in India. The remedy for the restitution of conjugal rights in India is provided under Section 9 of the Hindu Marriage Act 1955. Section 9 of the Hindu Marriage Act states that, I quote, "When either the husband or the wife has, without reasonable excuse, withdrawn from the society of the other, the aggrieved party may apply by petition to the district court for restitution of conjugal rights, and the court, on being satisfied of the truth of the statements made in such a petition and that there is no legal ground why the application shouldn't be granted, may decree restitution of conjugal rights accordingly." The explanation appended to this section states that where a question arises whether there has been reasonable excuse for withdrawal from the society, the burden of proving reasonable excuse shall be on the person who has withdrawn from the society. The term conjugal rights could be placed against any of the spouses guilty of staying away from the other party without a proper reason. If the suit succeeds, then the couple would be needed to stay together. There are 3 important requisites to be fulfilled for Section 9. These are: number 1, withdrawal from the society. Marriage implies consortium, that is, the husband and the wife are entitled to each other's company and comfort. Cause of action arises when one party withdraws from the society of the other. Number 2, Withdrawal from society must be without reasonable excuse. A petition for the restitution of conjugal rights will fail if it is established that the respondent has withdrawn from the society of the petitioner where there is a reasonable excuse for doing so. In modern matrimonial law, it amounts to reasonable excuse or reasonable cause. A. If there exists a grounds on which the respondent can claim any matrimonial relief. B. If the petitioner is guilty of any matrimonial misconduct not amounting to ground for a matrimonial relief, yet sufficiently weighty and grave. C. If the petitioner is guilty of such act, omission, or conduct which makes it impossible for the respondent to live with him. It seems here also that the reasons should be grave and weighty. The cases are clear. Thus, if it is established that the petitioner is guilty of cruelty or is an important person or is a subpoena to the respondent, the petition will fail. The cases falling under clause B and C present some difficulty. The Indian courts have held that any act of commission or omission amounting to reasonable excuse must be something grave and weighty. The Punjab and the Haryana High Court rightly observed that reasonable excuse is something less than a justification and more than a mere fad, whim, or brainwave. Any act or conduct which makes it impossible for the wife to live with the husband, or the inevitable conclusion that the couple can't live with harmony and happiness, will amount to reasonable excuse. Some instances of reasonable excuses may be husband's insistence that wife must live with his parents, wife's reasonable apprehension that it would be unsafe to live with the petitioner, husband forcing an educated Brahmin wife to eat meat and drink liquor, persistent nagging of wife by the husband's parents, addiction to drug or drink accompanied by violent temper, acts of physical violence, short of cruelty, overbearing, dominating and dictatorial conduct. Whether an act or omission is reasonable cause or excuse will depend upon the facts and circumstances of each case. The third important prerequisite for Section 9 is that the aggrieved party must apply for the restitution of conjugal rights. Now we come to the basis on which the petition for restitution of conjugal rights can be rejected. Number 1, if the respondent is capable of claiming any matrimonial relief. Number 2, if the petitioner accepts that he has committed any matrimonial misconduct. Number 3, if the petitioner's action makes it impossible for the respondent to stay with him. Now we come to the onus under Section 9 of the Hindu Marriage Act. Primarily, the petitioner has the burden to prove that the respondent has left him. When the petitioner successfully proves this, the burden shifts to the respondent to prove there is a reasonable ground to support as to why the respondent went away from the petitioner's society. Now, the constitutional validity of the restitution of conjugal rights. The question of constitutional validity of Section 9 of the Hindu Marriage Act 1955 for the first time arose in the case of T. Saritha versus Venkata Subbaiah. Justice Chaudhary, while declaring the remedy as violative of Articles 14, 19 and 21 of the Constitution, held that, I quote, "The Hindu Marriage Act was enacted by our Parliament in the year 1955 and the legislative competence of the Parliament to enact Section 9 of the Act under Item 5 of the List 3rd of the 7th Schedule to the Constitution is undoubted. But the question is whether that provision runs foul of Part 3rd of the Constitution." Unquote. The petitioner attacked Section 9 of the Act on the ground that granting of restitution of conjugal rights violates the petitioner's rights guaranteed under Articles 14, 19 and 21 of Part 3rd of our Constitution. The court, while examining the content of Article 21, held that Article 21 of the Constitution guarantees right to life and personal liberty against the state action. Formulated in simple negative terms, its range of operation positively any person of his life or liberty except according to the procedure established by law is of far-reaching dimensions and of overwhelming constitutional significance. Article 21 prevents the state from treating the human life as that of any other animal. It is now well established by the decisions of the Supreme Court that the word life occurring in the above Article 21 has spiritual significance as the word life occurring in the famous 5th and the 14th Amendments to the American Constitution does. In those constitutional provisions of the American Constitution, the life is interpreted by Mr. Justice Field in his dissenting judgment in Munn v. Illinois to mean and signify more than a person's right to lead an animal or a vegetative existence. Justice Field said in Munn's case, I quote, "By the term life, as here used, something more is meant than mere animal existence." Unquote. The contrast drawn by Justice Field, emphasizing the difference between the existence of a free-willing human and that of an unfree animal, was accepted by our Supreme Court first in the case of Kharak Singh versus the state of UP and next in the case of Govind versus the state of Madhya Pradesh. And then it was also accepted in Menka Gandhi's case and thereafter in a number of cases transforming Article 21 of our Constitution into a charter for civilization. In Kharak Singh versus state of UP, Justice Rajagopala Iyengar for the majority and Justice Subba Rao for the concurring minority accepted the above meaning and significance given to the word life by observing that the expression life used in that article cannot be confined only to the taking away of life that is causing death. Justice Subba Rao in the same case gave greater importance to the words personal liberty occurring in Article 21 of the Constitution. But both held that Article 21 of our Constitution to be the source for the protection of our personal liberty and life in the elevated sense. Justice Subba Rao perceptively observed that right to privacy forms a part of the guaranteed right of personal liberty in Article 21 of the Constitution. In a scientific age, psychological fears and restraints generated by the use of scientific methods, he feared, may constitute even greater denial of personal liberty than mere crude physical restraints of a bygone age. Justice Chaudhary termed the remedy as savage, uncivilized, barbarous, engine of oppression. He said that the remedy was tilted towards the husband, and through this decree the husband gets a right not only to the company of the wife but also to have sexual intercourse with her. Hence he termed this remedy as the grossest form of violation of human liberty and cessation of human choice. Here the court observed that a person gets access to one's body to be used as a vehicle for procreation of another human being. Therefore, the High Court observed that it is a savage and barbarous remedy violating the right to privacy and human dignity guaranteed by Article 21 of the Constitution and hence void. Sexual cohabitation is enforced through this remedy against individual's choice, violating Article 19, which talks about freedom of expression. As to being violative of Article 14 of the Constitution, that is, the right to equality, the court held that though it does not make any discrimination between a husband and a wife, but bear equality of treatment regardless of inequalities of realities, is neither justice nor homage to the constitutional principle. The Delhi High Court upheld the constitutional validity of Section 9 soon after T. Saritha's case in the case of Harvinder Kaur versus Harmandir Singh. Justice A.B. Rohatgi, while dealing with the argument that whether Section 9 offends Article 14 of the Constitution, referred to the judgment given by the High Court of Andhra Pradesh in T. Saritha's case, in which the learned judge has held that in the remedy of restitution there is inequality because a suit for restitution by the wife is rare. He has referred to a passage in Gupte's Hindu law in British India The learned Justice A.B. Rohatgi, while dealing with the issue, held that I have consulted Gupte's book. It is an old book of 1947 with a supplement of 1955. The author in this book says a suit for restitution by the wife is rare. This was true before the Hindu Marriage Act was enacted in 1955. Gupte was referring to old Hindu law and not to the Act because the Act had not been passed by then. Previously, under the Act, the decree holder alone was entitled to sue for divorce. By the Amending Act 44 of 1964, either party to a marriage is allowed to present a petition on the ground given in Section 13, Clause 1A. Even the party found guilty in restitution proceedings is entitled to petition for divorce under Section 13, Clause 1A, Subclause 2. The theory that one cannot take the advantage of one's wrong has not been adhered to in the Hindu Marriage Act. There is complete equality of the sexes here and equal protection of the laws. I do not see how Section 9 can be struck down as violative of Article 14 of the Constitution. The learned judge in Sarita's case has called restitution a barbarous remedy. He has quoted Lord Herschel in Russell v. Russell. While dealing with this, the learned Justice A.B. Rohatgi observed that Lord Herschel was not correct in saying this. What he was saying was that a reasonable excuse was not confined only to the grounds for divorce. It can as well be something short of legal cruelty which might constitute a reasonable excuse for refusing restitution. This is precisely what happened in India, as the history of the Act would show. Section 9(2), as originally enacted, provided that nothing can be pleaded in answer to a petition for restitution of conjugal rights which shall not be a ground for judicial separation or for nullity of marriage or for divorce. This created considerable difficulty. The Law Commission, in its 59th report, recommended its deletion. It is now possible for the party to plead a reasonable excuse which may not necessarily be a ground either for judicial separation or nullity or divorce. So the Act was amended and Section 9, Clause 2 was deleted. This brought the law in conformity with the opinion of Lord Herschel. The learned Attorney General argued that, I quote, marriage is not every casual commerce. A mere casual commerce without the intention of cohabitation and bringing up of the children would not constitute marriage, but when two parties agree to have commerce for procreation and for the bringing up of the children and for such lasting cohabitation, that would be marriage in the sight of God and man. Cohabitation continues to the end of life. It is not mere temporary or casual commerce, but a contract of permanent nature in the intention of the parties. Marriage is a contract of greatest importance in civil institutions, and it is charged with a vast variety of rights and obligations. He argued that Section 9 is constitutionally valid. Applying the standard that law has to be just, fair and reasonable, as enunciated in Menka Gandhi's case, Section 9, he said, tries to bring the parties together. Whether to grant restitution decree would be just, fair and reasonable in the facts and circumstances of a given case is left to the courts to be decided in its judicial discretion. What better guarantee can the law afford for the inviolability of the body and the mind of the wife and her marital privacy, so called? The matrimonial home must be reserved. It is in the interest of the state that family life should be maintained and that homes should not be broken up by the dissolution of the marriage of parents. Even in the absence of children, it is in the interest of the state that, if possible, the marriage tie should remain stable and be maintained. It is in public interest that marital life must be restored unless one spouse has adopted a course of conduct calculated to break the spirit of the sufferer, or a course of conduct which is a kind of a tyranny to the other spouse. The wisdom of the legislation the courts cannot question. It is the duty of the judges to give effect as best as they can to the laws as Parliament enacts, whatever be their private opinions or, in some cases, their religious beliefs. The judgment in Sarita's case is based on a misconception of the rule and of marriage. The court, while accepting the arguments of the learned Attorney General, held that it is to take the grossest view of the remedy to say that it subjects a person by the long arm of the law to a positive sex act. The restitution decree does not enforce sexual intercourse. This can be proved by a simple illustration. A husband and a wife are living under the same roof, but the wife does not allow the husband to have sexual intercourse with her because she thinks that it is horrid and a beastly thing. Will the court pass a restitution decree? The answer is no, since they are living together as one household, as one unit, and not as two. The law cannot go further and compel them to have sexual intercourse. The court has neither the means nor the capacity to enforce its decree in the marriage bed. It is most undesirable, save where we are clearly enjoined by the statutes so to do, to seek to discover or to reveal the secret intimacies of the marriage bed. If a question arises whether the marriage has been consummated, no doubt this may be necessary. It is not, I think, right that we should do so in a case such as the present. All that the court in a husband's petition under Section 9 does is to seek to inquire whether there is a reasonable excuse for the withdrawal by the wife from the society of the husband. It is a fallacy to think that the restitution of conjugal rights constitutes the starkest form of governmental invasion of marital privacy. The burden of proving reasonable excuse lies on the wife. A spouse is entitled to the other's society, and if the law enforces this conjugal duty, there is nothing wrong. It was further observed that this remedy is equally available to both the spouses and purports to preserve marriage, rebuild a broken home, and re-establish the two-in-one relationship between the estranged spouses. The Supreme Court in Saroj Rani versus Sudarshan Kumar Chad upheld the decision of the Delhi High Court. The Supreme Court held that having considered the views of the learned single judge of the Andhra Pradesh High Court and that of the learned single judge of Delhi High Court, we prefer to accept on this aspect, namely on the validity of Section 9 of the said Act, the views of the learned single judge of the Delhi High Court. It may be mentioned that conjugal rights may be viewed in its proper perspective by keeping in mind the dictionary meaning of the expression conjugal. Shorter Oxford English Dictionary notes the meaning of conjugal as of or pertaining to marriage or to husband and wife in their relations to each other. In the Dictionary of English Law, Earl Jowett defines conjugal rights thus: the right which the husband and the wife have to each other's society and marital intercourse. The suit for restitution of conjugal rights is a matrimonial suit cognizable in the divorce court, which is brought whenever either the husband or the wife lives separate from the other without any sufficient reason, in which case the court will decree restitution of conjugal rights. That is Matrimonial Causes Act 1950, Section 15, but will not enforce it by attachment, substituting however for the attachment, if the wife be the petitioner, an order for periodical payments by the husband to the wife, Section 22. Conjugal rights cannot be enforced by the act of either party, and a husband cannot seize and detain his wife by force. In India, it may be borne in mind that conjugal rights, that is, the right of the husband or the wife to the society of the other spouse, is not merely a creature of the statute. Such a right is inherent in the very institution of marriage itself. There are sufficient safeguards in Section 9 to prevent it from being a tyranny. The importance of the concept of conjugal rights can be viewed in the light of Law Commission's 71st report on the Hindu Marriage Act 1955, where it stated thus, I quote, "Moreover, the essence of marriage is sharing of common life, a sharing of all the happiness that life has to offer and all the misery that has to be faced in life, an experience of the joy that comes from enjoying in common things of the matter and of the spirit, and from showering love and affection on one's offspring. Living together is a symbol of such sharing in all its aspects. Living apart is a symbol indicating the negation of such sharing. It is indicative of a disruption of the essence of marriage, breakdown, and if it continues for a fairly long time, it would indicate destruction of the essence of marriage, irretrievable breakdown, unquote. The right of the husband or the wife to the society of the other spouse is not merely a creature of the statute. Such a right is inherent in the very institution of marriage itself. There are sufficient safeguards in Section 9 to prevent it from being a tyranny. It was remarked, I quote, "It serves a social purpose and as an aid to prevent the breakup of marriage," unquote. It was observed that the remedy gives the husband and the wife an opportunity to amicably resolve their differences and live together. It serves a social purpose and as an aid to restore the marital ties. It was submitted that no spouse could obtain the decree merely by filing a petition. If the court sees that the withdrawing spouse had a reasonable excuse for his or her withdrawal, then the decree is refused. The provision of reasonable excuse for withdrawal is built-in safeguard against the misuse of Section 9. Thus, this section is not violative of any constitutional provision. Now we discuss the ulterior motives of petitioners in restitution cases. One of the most fundamental problems with the remedy is the insincerity of the petitioner. The remedy is blatantly misused to achieve ulterior purposes other than reconciliation. There are two ulterior motives for this. Number 1, passport to divorce. Section 13, Clause 1A, Subclause 2 of the Hindu Marriage Act 1955 says that if a restitution decree has not been complied with for a period of 1 year, the parties can file for divorce. Generally, in restitution proceedings, after getting the decree, the aggrieved spouse does not comply with the decree willingly and after the statutory period of 1 year, files for divorce under Section 13, Clause 1A, Subclause 2 on the ground of non-compliance with the decree. There are many cases to corroborate this point. One such case is Malkeet Singh versus Shinderpal Kaur, in which the court found out the insincerity of the petitioner who deliberately kept the decree unsatisfied to obtain divorce, and thereafter the court refused to grant divorce on this premise. In fact, Justice Rohatgi in Harvinder Kaur versus Harmandir Singh recognized that the legislature has created the restitution of conjugal rights as an additional ground for divorce. Number 2, defense for maintenance suits. There have been plethora of cases in which the husbands filed petition for the restitution of conjugal rights just to counterblast the applications of their wives for maintenance under Section 125 of the CRPC. Some of them being Darshan Ram versus Maya Bhai, Gurdeep Singh versus Ranjit Kaur, Charan Singh versus Jayawati. In Veena Handa versus Avinash Handa, the husband, in order to frustrate his wife's claim for maintenance, sold all his property and distributed all his property to his relatives and claimed that he did not own any property in land. After the decree of restitution was passed, he filed for divorce after a year, on the ground that there has been no restitution for a year. When the trial court granted relief, he immediately married another girl, notwithstanding the wife's appeal against the divorce decree in the higher courts. This shows how restitution petitions are blatantly misused for ulterior purposes other than reconciliation. Moreover, restitution petitions are filed in district court. These cases go unreported, thus making it difficult to get an estimation of the actual number of petitioners who have been misusing the remedy. If we were to take into account these cases, then we would get the true picture of how the remedy is being blatantly misused. Conclusion. The Hindu marriage traditionally was deemed to be a sacrament union, which implies several things. That marriage between man and woman is of religious or holy character, that marriage as a union was primarily meant for the performance of the religious duties, and that the marriage was considered to be indissoluble union. But with the codification of the Hindu law on the marriage by the Hindu Marriage Act, the marriage among Hindus has acquired a contractual nature. The Act, by providing several matrimonial remedies such as divorce and nullity of marriage, eroded its sacramental character. The changes further brought about by the Marriage Laws Amendment Act 1976 are revolutionary in character. For example, divorce was further liberalized. Section 13B was introduced, which provided for divorce by mutual consent. The period required to elapse before a decree of restitution of conjugal rights or judicial separation, which has not been able to bring about reconciliation, could become a ground for divorce, was reduced from 2 years to 1 year. Desertion, which was earlier a ground for judicial separation, was made a ground for divorce as well. This act brought about a tremendous change in the entire conception of marriage over time and made it primarily contractual. With the entire concept of divorce by mutual consent, it is clear that the court no longer hinders the breaking off of a marriage if the parties are too estranged to reconcile. As restitution of conjugal rights was primarily based on the sacramental character of marriage, with its degradation, the remedies foundation has shaken up. This was all about today's lecture. Hope you have understood it well. We shall meet again with a new topic. Until then, take care of yourself. Goodbye.